Most lawyers believe that more risk means less safety. I think that's fundamentally backwards and wrong. In the product that we are working with insurance companies, working with our clients in traumatic brain injury litigation specifically, risk isn't something to avoid, it's something we embrace. It is our product. The side, if it's our side versus the defense, whoever builds the most risk on the other side wins, because that drives settlement more than almost anything else. And so this episode is something that I want more lawyers to talk about, I want more lawyers to think about, and fundamentally, you need to understand how to weaponize risk as leverage, because fear shouldn't be something that we run from. It should be something that we hug. Like, the sooner we lean into the facts of our case, good or bad, the ones that create the highest emotional understanding, that is where the specifics go that will drive the jury decision-making process. So, getting to it. My name's Taylor Ernst, 2024 California Lawyer Attorney of the Year. I've gotten 20,000 lawyers and doctors throughout the United States educated on TBI cases. I wrote the book on TBI litigation, and I've gotten a $63 million verdict. So when I'm talking about this stuff, this is something that I want you to understand. Not only did I get it from reading books and white papers and trying to figure out, like, how's this specific neuropsych exam work, or how's this MRI study look? That's not where I got this information. I got this information from living it day in, day out. Most lawyers think risk is something to avoid. In TBI, it is the product. The defense sees risk in TBI cases as not that significant because it's invisible. And when risk is invisible, the insurance company, the adjuster, the lawyer, it's easy for them to think there's no risk because you can't point to something on a scan. They think the ability for a significant verdict isn't there as much. So once you understand that risk is the product we are selling to the insurance company, whose their entire job is, there's literally jobs in the insurance company called risk management. And if they've got jobs called risk management, it's something that lawyers should pay more attention to. So once you start paying attention to the amount of risk you're creating, everything changes for you. I have 3 stories that I want to give throughout this podcast of TBI Lawyer Secrets, and they're the following questions answered. What happens when there's no risk? What happens when there's massive risk? And what do we do when we aren't sure where the risk is? How to find the hidden risk. So each of those questions forms basically the background of 3 stories that I lived. So the first one is when there's no risk from the defendant. And this is a trial I just went through a month ago. So let me tell you a few of the facts of the case, and you will understand why the defense felt safe. Our client was injured. He was hit on a bike by a car. The ambulance showed up, but he didn't go to the hospital. He left the scene of the incident on a bike where he rode 20 miles home. He then went to the hospital 9 hours later where he was diagnosed with a head injury. And then he didn't have brain injury treatment for 3 years. So the defense views that and they feel safe. There's nothing at stake for them to lose. They think us going to trial against a $100,000 offer from them is insane. They just think we're idiot lawyers, is the truth. They basically think you didn't evaluate the case correctly, which in every jury trial, someone didn't evaluate it correctly. We just aren't sure who it is yet. Something I actually really like to say to defense counsel is, like, we're about to find out who misevaluated this. I'm not sure who it was, because, like, that's the truth of it. And when we go into a trial like this and the defense doesn't offer significant money, that in itself is telling us something. When the defense says, hey, the offer is $100,000 or you get to try the case, they are telling me I've created zero risk in them, that they're really worried about a, $2 or $3 million verdict. They just don't think that's likely. And statistically, they look at all the numbers, they look at all the lawyers are doing, they do average case valuations, which, by the way, if you're getting lumped in with average case valuations, you're probably needing to do something to basically take yourself out of that group, because you'll get better offers. Like, you should have the mediator or the defense at some point on your big cases be like, yeah, we know this is the average, but we're going to pay you significantly more than that because we know the reputation of your firm. So that's something that it's a whole other conversation, but that's something you need to lean into and start building that, because that reputation in itself creates risk. But even with the reputation, we went into this trial and they basically are like, yeah, lowball offer. We're not going to give you any real offer there. And because of the lack of risk, they signaled to us, we didn't create any, we had to try it. And the jury that case turned out well. You can see the verdict here. But basically, the entire concept of what happened in that case is because we had no risk, we had no choice but to try the case. That was just built in from the get-go because they evaluated it and go, if he went home from the scene and there was not a significant diagnosis and he didn't get treatment for a long period of time, they just don't think there's ever going to be an excess verdict. The next one is what happens when there's massive risk for the defense. Everybody knows the answer to this. Well, obviously, you settle the case. They look at it internally and be like, oh man, there's a ton of risk here. We should figure out how we can settle the case. But what's more important about that is the way that you create risk. You do not want to tell the defense, hey, the basics of once you get some leverage on them, you think, oh, I can sit back. I know they have a ton of risk. I'm good to go. It's something that I've seen mistakes made time and time again where the plaintiff lawyer thinks they've got the bad fact and the defense will never try the case. When you get a bad fact, facts are not usually only in one place. Usually it's a series of bad facts. And if you know one, you should go hunting for 5 because the fact that you get one and think, I'm done, put your feet up, think, oh, they're going to settle it, is one of the biggest mistakes I see plaintiff lawyers making. And I know that because I used to do it. And now when we talk about it in our office of where there's smoke, there's fire, you find the first bad fact and you go, all right, where's the 4 others? Because it goes from the defense arguing at trial, oh, this was just a mistake and it was just an accident. And how could we have possibly known? To you can use one of the strongest metaphors that we talk about in the Ernst Way book that's releasing is basically you go out and you design it to be a deliberate series of choices that led to, and you pick a metaphor, the fire alarm's going off. Wasn't the fire alarm was pulled once. It wasn't pulled twice. It wasn't pulled 3 times. It was pulled 4 times. They had 4 opportunities to prevent this accident from happening. And every single time they chose the thing to make the business more money or to avoid the safety or whatever it is. And it becomes such a deliberate throw fuel on the fire of the choice that led to your client's harm. Quite literally, adding no risk is bad, but once you get significant risk on the defense, you need to go there hard to make the ability of getting so much more value for your client that I cannot begin to tell you. I had a defendant call up. They found out we signed the case and they called me just out of the blue, and it was their counsel. So I'm in California. We do cases across the country, but I got a counsel calling me from Oklahoma, and he was like, yeah, I'm their primary trial counsel. I'm calling you. I know you haven't even filed it yet, but we want to offer you 7 figures to get this case done. And I'm like, oh, that's interesting. And he's like, so, can we talk? Can we get this worked out? Like, he literally was offering me money on the phone. And what I told him was no. And he's like, what? He's like, you're going to turn down an offer pre-lit? I'm like, yeah. And he's like, why? I'm like, I want to find out what else happened in this case. And he's like, well, no, you can't really, like, we're offering you significant money now. This is good money on your case. And I was like, yeah, but no. And he was like, why? And I'm like, I want to find out all the other stuff that went wrong in this case. And we took the pre-lit 1 to 1.5. They were sniff around for that, maybe 2 if I leaned on them hard. And I just shut it down. The conversation was maybe 30 minutes. And in the final result, it was an 8-figure case. And it was just because we knew there was smoke. We knew the fire was there. We went so hard after all the stuff that the TBI case became something that was so much higher leverage. Looking back on it, I think if they got a call pre-lit and said, hey, we're going to offer you this much money, I think most firms would have done it. And I got this sense of we need to go hard on this risk. And it's been something I've been talking about more and more. And once we do that, it has worked for our firm so many times now that we have a bunch of sayings and playbooks internally that we talk about of like, oh, there's significant risk here. Let's go hard on this. So when you find that significant risk point, it becomes almost like a gravity towards itself. It's why that certain cases, like one bad thing happens and then another bad thing happens and then a bunch of other bad things happen. It's because nothing happens in a vacuum. The more something starts going sideways, the more it tends to snowball and get worse and worse for the side that it's going badly for. So truth is not neutral. Everyone talks about truth and like balancing the scales and that whole thing. The concept of truth is it's the truth. And so if you start finding a bad fact, you think of it as there's 10 bad facts and you only found 1. And so the whole concept of, oh, you only found 1 bad fact, it's time, the defense isn't going to put real money in, they're going to settle the case. No, that couldn't be further from the truth. That's where you really need to say, oh, hey, like something really went wrong here. Let's go figure out why. Not only that, for community reasons, if you go find the thing that went really wrong, and you magnify it and get the defendant to realize all the bad things they do, they will fix them. Companies inherently tend to, I think, want to do the right thing, sometimes for money reasons or personnel reasons or other things they don't. But when you make a financial significant penalty for them, balancing the scales for what they did to your client, it is something that resonates and I think can actually make the world a better place. The third story is what do you do when you have the case where you're like, well, there's not no risk, but there's not a ton of risk either, but there is something that went wrong. The question I always ask, and I'm talking about to lawyers, is, well, what was the real cause of this? And I think that question is difficult to answer inherently because especially if it's like a construction site accident or a plane crash or an elevator failing or whatever the thing is that leads to the TBI, which all of those have their own ways of causing the TBI. Finding out the core problem, you then have to ask the questions of why did this happen? Like what went wrong that led to this? And give you a construction example is I had a case a number of years ago. We sued a German manufacturer that sold, I think I actually have it here. Yeah, I do. Neat. We're going to block out the name of the company. Great. German manufacturer. It's this heavy construction crane thing. Kind of cool. And what happened was this thing lifts up pillars. They go into the ground. They're basically 7,000 pound beams. And it lifted up this 7,000 pound beam. The chains broke and the 7,000 pound beam came over and smacked the roof of the cab that our guy was in. And he, skull fracture, brain bleed, not good stuff. We kept asking, like, why would they pull the beam up in a way where the chains could break? Isn't this something they would have known about ahead of time? Like, why did they not do something about it? And just for, I do mostly TBI stuff, but just to give you the framework for any product liability cases, the framework you want to use is eliminate, guard, warn. First, you see if you can eliminate the issue. If you can't eliminate it, you guard against it. If you can't guard against it, you warn about it. And then you basically do the whole setup of the significant risk of the company had the ability to engineer this in a way to eliminate it. They didn't. They had the ability to guard against it. Did they do that? No. Did they have the ability to warn? They should have told them, hey, watch out. This beam could fall on you if these chains break. They didn't do any of those three things. That was the framework we used asking, why did this happen? And we kept looking at, well, why didn't they eliminate it? Well, the truth was they couldn't because they got to pull it up that high in the air. But why didn't they guard against it? And we asked a whole series of questions, which asking questions to a German manufacturer, that's this whole set of other problems. But what we found out is they actually made a device to guard against that specific type of failure, but they only sold it in Germany. They never marketed it in the US. We found the brochure and flyer, and it's exactly what is going through your brain now. Hey, they knew about it. All of a sudden, that case value goes up significantly because now if the defense goes to trial on that, they can't admit it because there's too many other issues in it. They're going to have to try the negligence and product liability portions of it. And all of a sudden, we have a fabulous story to tell that makes their risk so much more significant, which is why it's settled on the first day of trial. So what else do you want to understand about the risk creation that we are talking about in TBI cases? Is where you feel safe is not, it's like a reverse emotional reaction of on the cases you feel the most safe on, that's the ones where you need to do significantly more work to get even more leverage. And what I call intellectual capital, it's the intelligence of the people working around you. The higher you can get the intellectual capital, it basically creates this formula of creating risk for an insurance company. And it's intellectual capital multiplied by the credibility of the firm. And the credibility of the firm is basically your reputation. So like the defense keeps track of who tries cases and who doesn't. And the higher you can have intellectual capacity or intellectual capital, then you add to the credibility. And the last is how much uncertainty can you create with those first two variables? And that's basically the formula. So the higher level of intellectual capital that you can have multiplied by the credibility that you have creates the level of defense unease they have when they're like, oh, hey, who's this firm? How good are they? How likely are they to try the case? So going back to it, you don't win TBI cases by being safe. You win by figuring out a way to make the defense realize the risk they're going to face at trial if the jury's looking at it and be like, yeah, you really did cause this TBI, and we know it because of this, this, and this. And whether you are creating risk in terms of setting up the liability case, or more importantly, especially on TBI cases where the defense lawyers, they understand these. You need to give them a reason to have significant risk on the TBI portion of the case, where even if it's an invisible injury, even if your client's going to walk in and tell them, I'm still working, I'm still talking, I can answer questions, versus, I mean, I've had cases where the client's literally wheeled in and she can only move her eyes, and the jury gets to see her and they can't even talk to her because she can't communicate. Those type of risk increase that you can give is the most valuable thing that you can do for all your cases, whether you settle them, where you try them, because adding risk helps you settle the case better because they'll pay you more because they recognize the risk that's created. Even if it doesn't settle, the ability to create risk allows you to put a better story on at trial. So, as I said earlier, truth isn't neutral. Truth is the weaponized risk. And if you figure out a way to make the truth give the real story to the defense about the failure that they had and the failure that led to the significant problems that are going to make your client have basically issues for the rest of their life that they're stuck with, that they didn't sign up for, that is the product that, as a lawyer, we all talk about taking depots and the Perry Mason moments at trial and all the things that we think move the needle. And so let's see if I can break it down even more. I kind of view risk as almost like a ladder where there's 4 different rungs of what we need to do to be able to get that information to the defense. Because more than anything, it is like telephone. Like, we tell them through paperwork or a depot or through some mediation brief, here's the information about our client. So they basically need an awareness of the problem of like, what is the risk here? And like, I've had trials where I quite literally am in trial and the defense lawyer will ask me a question about the scan, being like, oh, the scan's negative. And I can, this is what my face was doing. Basically, he was like, oh, the scan's negative. And I'm like, oh my God, scan's not negative. And he's like, well, it said no intracranial bleeding. I'm like, we didn't allege that this made him bleed in the brain. We alleged that he had a hole in his brain after. And he's like, what do you mean? That's not what the MRI says. And I'm like, you just don't understand the medicine. And so being aware of the risk that you're creating is pretty important, because if the defense lawyer doesn't understand what your case is about, it's pretty hard for them to get enough money to make the case settle. Then you need to make them understand. So first is awareness. Second is basically the amplification of the awareness of the risk. Is like, okay, so they've got a hole in their brain. What's that mean? What are the actual numbers from the hole in the brain gonna be? And it really goes back to the concept of, so what? So if you've got a hole in the brain and the frontal lobe, it's executive dysfunction, personality, versus the parietal lobe, it's a whole different thing. And so you need to figure out a way to make hard numbers tied to the awareness of the defense. So like, again, if he doesn't know there's a hole in the brain, it's pretty hard for him to get you money. Then it's hole in the brain plus what is the result? Do they need someone that's going to take care of them for the rest of their life? Does that start now? Does it start when they're 65? What's that look like? Then you need to create, so first is awareness, second is amplification, third is asymmetry. With asymmetry, it's how much does the defense understand versus how much we understand. If I say, hey, I'm going to ask for $7 million at trial, and the defense is like, what do you mean? I thought you were going to ask for $1 million. Basically means they understood this much about my case when I need them to understand this. And that delta of what I need to get them to understand of why when I'm like, oh, I'm going to ask for $7 million, they basically are like, that's it. Like, they need to understand that I'm trying to be credible when I make that ask. And the last thing is, of all those things, if they understand the awareness, you can figure out a way to give them the hard numbers and amplify what the awareness of the problem was, close the asymmetry as much as possible. And the fourth one is action. So it's awareness, amplification, asymmetry, and action. If you do not have the last one, if you don't have a way for the defense to report it or a way for a mediation always creates action in the defense because they have to write all these reports, or the trial coming up or a trial readiness conference. You need to give them a lever to actually go do something. The one that I use that is my favorite is to say, hey, there's been a material change in the case. And I just tell them what I think the material change is. Hey, there's been a material change in the case. My client had another seizure. And they're like, what? What do you mean a seizure? Well, he had a seizure because of the brain injury, and now he got his license taken away. There's been a material change in the case, and what we were talking about before in our settlement value is no longer what we're talking about. That creates the type of paper trail the insurance company needs to be able to evaluate the case in the way that you want them to evaluate it. It all goes back to, it's almost like a funnel. The higher awareness of the problem, and then how do you amplify the problem? How do you close the asymmetry of the information? And the last one is, how do you make them actually take action on that? And the action is something that makes them value the case in the way that you value it. So that's it. That's the high level way I think about risk. It's awareness of the problem, the way you can amplify the awareness of the problem, generally with hard numbers, the way that you can get the asymmetry of what's the information they need to understand so that you and them understand the case in the same way. And the last one is, what can you do to have them take action on the thing? More than anything else, lawyers do not spend enough time talking about risk creation, especially on TBI cases where our clients look like they have an invisible injury. And so how do you take that invisible injury and make it the truth of what your client's living in a way that the defense understands the risk if you go to trial? More than anything else, this is TBI Lawyer Secrets. Taylor Ernst. I'll see you next time. Thanks.